Mr. Stout, right?
Correct, Your Honor.
And there was some objection as far as the framework of his testimony. And so I wanted to do, when we discussed previously, doing a brief hearing at which I really just want to inquire about the reliability of the methods that he uses to reach his opinions, as well as the fact of whether or not he's reliably applying the facts and circumstances of this particular case. That is kind of what my intent was, and I believe we're all on the same page in that regard.
Please, so, Your Honor.
And Mr. Consolio.
I agree, Your Honor. I understand the court's direction.
And also, before I have him come in, I want to make sure that I am correct, that there's no objection to him testifying as an expert in the field of use of force. The issue is the officer created jeopardy theory that he is, that we're assuming he's going to testify about.
As far as credentials as a professor of law that specializes in use of force, we don't object to those, Your Honor. We have filed several motions in the past regarding the relevance of his testimony, and obviously we filed motions regarding, in particular, the officer created jeopardy theory that Professor Stoughton uses to form his opinions. And so we're not waiving any of those prior motions or objections, but as far as his qualifications as a professor, we don't object to those. I assume Mr. Becker's still going to put some of that on the record for the jury.
So you're still objecting to him testifying as an expert? You're not saying that he's not qualified to be an expert, but you're still objecting to him providing testimony?
We're objecting to the extent that his opinions are based on officer created jeopardy theory as irrelevant. And we've already put that in a motion. And we also are objecting that the officer created jeopardy theory is not generally accepted. And that I believe that's what the purpose of this hearing is for. My understanding is the court has already deemed his testimony relevant in the past, because you denied our motion to exclude it based on relevance. But you wanted to revisit the issue of whether officer created jeopardy theory itself is generally accepted, and I'm going to limit my questions to that.
Okay. Okay, but you don't object to him. Are you putting him forth as an expert, or do you intend to ask him to be accepted as an expert in the field of
police practices and use of force, Your Honor?
Okay. And the police practices is the framework under which officer created jeopardy would ostensibly be placed. So I'm asking, do you object also to the use of force testimony that Mr. Stoughton may provide? And I'm asking because obviously that would be included in the questioning at this juncture.
So you're asking whether or not we believe he's qualified to be an expert in the use of force. We do not. We believe he is qualified given his academic credentials and issues of use of force. We believe he's qualified to act as an expert on principles espoused by the Supreme Court, Graham v. Connor, and subsequent cases. He's written books about use of force. As far as tactics goes, and what a police officer should do, and training, we do not think he's a taser expert. We do not think he's a tactical expert. Police practices, what's generally accepted in conforming with Graham v. Connor, we believe he is knowledgeable enough on that to provide his opinion. We just think his opinion about officer created jeopardy is not relevant.
Okay. And so I think we have the kind of the ground rules, so to speak, for this portion of the questioning of Mr. Stoughton. So are you ready?
I can see, Your Honor. And Ms. Blige will be taking the questioning for this portion, Your Honor.
So you're going to have people call Professor Seth Stoughton.
Good morning.
Good morning.
And sir, before you take your seat, if you please raise your right hand, my clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Thank you.
Good morning, Professor Stoughton.
Good morning.
As you heard the judge's opening, we are here for a bit of a focused inquiry, so this will be a bit different than a general expert voir dire, but we will focus in as necessary.
Sure.
Are you present in court today to potentially offer testimony as an expert in police use of force tactics?
Yes.
And did you prepare a CV in anticipation of testifying in this trial?
Not specifically for this trial, but yes, I
Provided to counsel.
keep the CV on hand, yes.
Your Honor, just for purposes of expediting today's hearing and jumping over qualifications, his resume updated version has been provided to defense counsel previously. Would you like to get a copy?
We don't need a copy, and we understand we have a copy.
May I approach the witness? Does this appear to be the most updated version of your CV?
Yes, it does.
Your Honor, the people would provide the court, just for purposes of this limited evidentiary hearing, with a copy of the expert CV. It's not marked as an exhibit. We don't plan to measure it to the jury
We'll probably do a Roman numeral 1 for it.
for the evidentiary hearing.
And is there any objection to it being omitted for that purpose? So exhibit Roman numeral 1.
No objection.
Here's an exhibit number from the court. And just briefly, Professor Stoughton, where do you currently work?
At the University of South Carolina Joseph F. Rice School of Law, which I'm contractually required to say the full thing.
And what is your title there?
I am a professor of law, and I'm the faculty director of the Excellence in Policing and Public Safety program there.
And how long have you served in this position?
As a professor since June of 2014 with EPS, the Excellence in Policing program, about 2 years now.
As a professor, is it safe to assume you teach classes to law students as part of your duties?
I do. As a professor of law, I teach in the JD program, our law student classes, yes.
And in general, in your position as a professor, do you do any research?
Yes.
Do you do any writing for publication?
Yes.
And I assume you research and write on a variety of topics, but does your work specifically include research on the topic of officer-created jeopardy?
I wouldn't call that a specific topic. I research in the area of police tactics, and officer-created jeopardy is a concept within the field of police tactics, yes.
So your research on police tactics involves the theory of officer-created jeopardy?
Yes. Even calling it a theory might be a little grand, but yes, certainly that concept.
How would you define the concept of officer-created jeopardy?
Officer-created jeopardy is really just a term of art that's used to describe unjustified risk-taking. When officers use tactics that they should not use, and as a result of that, the poor tactic increases the danger to the officer, we could call it bad tactics or unsound tactics. The phrase that is used is just officer-created jeopardy.
And when you are performing this research and discussing the concept or term of art of officer-created jeopardy, what methodology do you use in your research?
So it depends on exactly what I'm researching. For researching the history of police tactics, it is essentially going back to the early days of formalized police training in the 19-teens under August Vollmer and identifying what police training consisted of. There's a good article from 1929 that identifies that police tactics was among the list of things taught at the early police training schools, as they were called. going through sort of history of policing and looking at tactics, the real emergence of police tactics as a field and what's sometimes referred to as the tactical revolution of the 1970s, with police practitioners and scholars like Jim Fife, Peter Scharf, Arnold Binder, a number of other folks working in that area to identify the framework for examining use of force incidents, which includes a tactical component, and looking at more modern practices. It's identifying tactical guidance provided in police training at the 650 odd academies or at some of the larger agencies that develop their own tactical training, seeing how those concepts are reflected in guidance by, among others, the Police Executive Research Forum or the International Association of Chiefs of Police, to get an understanding of how tactical concepts bubble up from the field and become generally accepted.
So your methodology includes examining how these police tactics have evolved over the course of history.
Oh, sure. Yeah, absolutely. There have been some very notable changes in police tactics. And one of the things that's important in examining any particular incident is identifying what the tactical guidance was at the time. If you looked at active shooter situations prior to 1999, the tactics were different than active shooter response today, for example.
And at what point does your research reveal that the concept or term of art officer-created jeopardy entered this police tactics discussion?
Yeah, again, it's just a term of convenience. It's a term of art. That started in the 1990s, mid-1990s, with the Savannah Police Department. They're the ones who first introduced that concept. Or I should specify, termed that concept officer-created jeopardy. There were discussions of the concept well prior to that, but that wasn't the term until the Savannah Police Department introduced it.
So the concept has existed historically, but the term originated approximately 30 years ago. Is that what
yeah, that's about right.
And when you're researching in the area of police tactics, what are the sources from which you draw your conclusions?
So again, it depends on exactly what I'm researching. For historical practices, it's historical training documentation. I don't really do qualitative work in this area, so I'm not interviewing people about what tactics used to be like 30 years ago. I'm usually looking for tactical training manuals. Most of those resources are not academic in nature. Most of them are practical or practitioner resources. So some of the early publications by Caliber Press, like Street Survival or the like, that sort of channeled popular understandings of tactics in the 70s and 80s. More modern research looking at police agency policies, looking at organizations, again, like the International Association of Chiefs of Police or the National Police Foundation or the Police Executive Research Forum, to see how they are writing and describing practices that have bubbled up from the field. Along with looking at training documentation, agency policies, there's some use of, say, popular police media. So tactical articles on websites like Police Magazine or the like, not to identify any of them as a definitive source. They are not, no one article is a definitive source, but when you see the same sort of baseline message of this is the scope of professional practices at this point in time, that's how you identify a generally accepted practice.
So do you survey all of these different publications to source your eventual research conclusions and opinions?
Yes, both the academic literature, the professional organization literature, and the practitioner literature, yes.
Are these sources nationally recognized among the expert community?
Yes, yeah. I mean, the International Association of Chiefs of Police, for example, which publishes a lot of model policies and discussion papers, as well as a national consensus policy and discussion paper on the use of force. They are the largest and oldest police organization in the world. Police Executive Research Forum and National Police Foundation are both extremely well known in the police practitioner as well as the research community. When you talk about individual articles, academic articles, they may not have the same degree of penetration into police practice. There can be a pretty hard line between where police agencies get guidance and what academics are working on. But within the academic communities that look at this, yeah, I'm looking at well-published articles by well-known scholars.
And as we've covered, you're a professor, correct?
Yes.
Are you also an attorney?
I am. I'm a non-practicing attorney in the Virginia bar.
And does your experience also include experience as a law enforcement officer?
Yes, it does.
And with your educational and professional background, does that give you a unique perspective, as you've said, on all of these resources, be it academic, legal, law enforcement based?
I wouldn't want to say it's a unique perspective. It's not particularly typical. There are a number of law professors who focus on policing. Hosting a conference for them in June, as a matter of fact. There are a number of criminologists who focus on policing. Some number of them are former officers. Relatively few are former officers turned law professors who focus on policing, but there might be a couple others.
So you've mentioned how you collect your research and your methodology. Beyond researching, do you write and publish yourself?
I do, yes.
Does this writing and publication include discussion of this concept, officer-created jeopardy?
Yes, it does.
Have you published books that cover this topic?
The book, very creatively titled Evaluating Police Use of Force, talks about it in Chapter 5, the Tactical Considerations chapter, yes. I've also written book chapters in other books, consolidated books that have talked about it.
How about any law review articles?
Yes.
Any other articles or publications that come to mind where you've discussed officer-created jeopardy? Those are the main categories. Amicus briefs, perhaps?
Amicus briefs, yes. I've done amicus briefs that have talked about officer-created jeopardy, not from the perspective of an expert applying tactics in a case, obviously, but in the context of an amicus. I'm trying to remember if I write in both law and criminology, and I don't remember offhand if any of my criminology articles get into officer-created jeopardy.
Do you recall in what courts you have filed amicus briefs on this topic?
The United States Supreme Court, I think the Fifth Circuit Court of Appeals. I think those are the only courts I've done amicus briefs in on this issue.
And those are both federal courts?
Yes.
Yes. When you publish these articles and books, have you ever seen them cited by courts or other experts in your field?
Yes.
Do you recall any specific citations?
Kind of breaking it up broadly, there are a number of academic citations, that is citations to my work by other academics in an academic context. That's true most obviously in law and criminology, but also in some other disciplines, psychology and geography and a couple of others that I don't entirely understand why they're citing me, but they do. Outside of academics, in police practices, my work is cited or used fairly heavily in training on reviewing police uses of force in front of state organizations. The one speaker sent me a slide about some of my work from the Pennsylvania Organization of Municipalities or something like that, the sort of blanket body for cities that have police departments. My part of the book on tactics was just cited by the 11th Circuit Court of Appeals, the Federal Circuit, focusing on a couple of tactical principles from that same chapter, Chapter 5.
And Chapter 5 was the chapter that discussed the officer-created jeopardy that you mentioned?
Yes, as part of the discussion of tactical considerations, yes.
Are there other experts in the use of force community who also research officer-created jeopardy, or is it just you?
No, there are a number of us who either research it or use that description of unjustified risk-taking in various aspects of our work.
And have you ever testified as an expert in court before?
Yes.
Do you recall any of the court, state, federal, state courts specifically that you've testified in?
Oh, yes. I testified in state courts in Minnesota, Ohio, Georgia, Nevada. I'm sure there are some other ones. Federal courts, South Carolina. I've testified in federal courts in South Carolina, North Carolina. I would have to look at my CV to remember.
I think that's a sufficient list, and the court has your CV for its review as well. Could you ballpark about how many times you've testified as an expert witness in use of force tactics?
Probably upwards of 24 at this point. If you include depositions, it would be more than that, but with actual trial testimony, 24, maybe a little more.
And has your expert testimony ever covered the concept of officer-created jeopardy in court?
Yes, frequently.
Have you ever testified or provided this officer-created jeopardy discussion in police use of force cases specifically?
Yes.
About how many out of your 24 times would you estimate it was a police use of force case?
Oh, that involved some aspect of tactics or potentially unsound tactics. This is very ballpark, but maybe half or so.
Have you ever been excluded from testifying as an expert witness in court?
No.
Do you ever teach or train others regarding this concept of officer-created jeopardy?
Yes.
And in what context is that?
So I teach use of force review and evaluation in the program that I run at the law school. We have a week-long course on critical incident and sentinel event review that covers aspects of reviewing use of force. So we talk about the role of tactics in use of force. I think we mention by name officer-created jeopardy, but only relatively briefly. Again, that's just a term of convenience more than it is an actual self-defining separate thing. I have twice taught at the Washington, D.C. Metropolitan Police Department's Police Leadership Academy on reviewing use of force. They have between 70 and 80 officers from all over the country, and actually all over the world. They have 6 or 8 officers in every cohort from other countries. And in that discussion, similarly, I talk about considerations in use of force review. That includes tactics, including this concept of officer-created jeopardy. I've done, I don't know how many speaking presentations to shorter audiences instead of a full-blown course or something like that for judicial audiences, legal audiences, police executive or officer audiences. A lot, many of which touch on this concept of tactics as it relates to use of force.
Does that dovetail at all with your experience providing subject matter expertise or consulting services?
In some sense, yes. They cover some of the same topics. There is a distinction, there is a difference when I'm teaching a course, especially one of the courses for police executives. The focus is not on identifying generally accepted practices, the focus is on sort of building up best practices, and there's a noticeable difference between best practices and what is generally accepted. My role as an expert is not to identify what the best practices are and hold officers or agencies to that standard. My role as an expert is to identify what's generally accepted and at the time of the incident or decision. Same topic, different standard, different role, if that makes sense.
So you mentioned generally accepted police practices. Could you provide a bit more of a definition of what that means? Not best practices, as you said.
Sure, yeah. So generally accepted practices is really the sort of common elements of professionalism. It's the standard of care in policing. We just happen to not use that particular phrase. It's the idea with generally accepted principles or practices, and I can separately define those. These are concepts or protocols that have, again, typically bubbled up from the practice of policing and become so commonly accepted that more or less, to put it very colloquially, if you went to any reasonably trained officer anywhere in the country and said, is this more or less the way you do things, they would say, yeah, that's more or less the way we do things. Not everything in policing has a generally accepted practice, and even within generally accepted practices, there's often a fair amount of room for variation, but there are still both sort of floor and ceiling, or maybe a better way to put that is there is a minimum level of professional expectation. To meet the expectations of the professional community in policing, an agency or officer should be doing this thing or not doing that thing.
Would you classify officer-created jeopardy, I guess put it this way, is the concept of officer-created jeopardy incorporated into generally accepted police practices?
Properly defined, yes, absolutely. Understanding officer-created jeopardy as unjustified risk-taking, yes, completely. Again, police agencies have been teaching officers about tactics since at least the 1920s, 19-teens. There's been both academic and popular focus on it in the 70s with that concept of tactical revolution that I mentioned. Yes, understanding tactics as a tool to keep officers safe and as a result to keep communities safer. Officer-created jeopardy is certainly generally accepted. It's not always understood in that term, right? But again, that's why I'm defining it here, specifying that it is a term of art. An agency might not have anything in their policy manual or training that says officer-created jeopardy, but they certainly have things in their policy manual and training that talks about tactics, the need for good tactics, the need to avoid bad tactics, the result of what bad tactics can be, making the use of force more likely or exposing an officer to danger. So yes, all of that is generally accepted.
Could you give us a quick example of a tactic that incorporates an officer-created jeopardy concept?
Yeah, so the easy one and the one that we use in the book is stepping into a vehicle's path of travel. Stepping immediately in front of or immediately behind a vehicle, especially a moving vehicle, but even leaving that aside. The tactical analysis here is relatively straightforward. You ask what are the potential benefits and what are the potential risks. The tactical benefits of stepping in front of a moving vehicle are minimal. You're not going to stop that vehicle, right? Just as a simple matter of physics, vehicle beats person all the time. Maybe there are some slight tactical benefits, potentially a benefit to visibility or something like that, but the tactical benefits of stepping into a vehicle's path of travel are relatively minimal. On the other hand, the tactical risks are substantial. Again, vehicle beats person. So an officer is far more likely to be struck, dragged, seriously injured, or killed by stepping into a vehicle's path of travel. For that reason, it is generally accepted as a matter of police practices that outside of extraordinary circumstances, officers should not step into and certainly should not stay in a vehicle's path of travel.
Prior to your experience as a professor or attorney, did you serve as a law enforcement officer?
I did,
And what department was that with?
with the Tallahassee Police Department.
How long were you an officer with Tallahassee?
I was full-time with them for just under 5 years and stayed on as a reservist, a part-time officer for another 6 months or so.
And in that capacity, as a law enforcement officer, were you exposed to officer-created jeopardy concepts during your training?
Sure, yeah, tactical training, again, very common both at academies generally, definitely part of my academy experience, as well as in-house training and field training, yes.
And specific to the case that you're here for today, did you review any evidence to prepare for your anticipated testimony?
Yes.
Do you recall any of the specific evidence that you did have a chance to review?
There were 3 different videos, as I recall, a dash cam, a body cam, and a bystander cell phone camera. There were some statements and investigation. There were policies and procedures and training records. I'm sure there was more. I could look at my report and give you the list of materials that I reviewed, but I don't remember the rest offhand.
Nope, that's a good list. So after your review of all of this evidence, did that adequately prepare you to apply your research and writing to the facts of this case?
Yes.
One minute, Your Honor. No further questions at this time.
Professor Stoughton.
Good morning. I like your tie.
Thank you. I like yours.
Thank you.
So, I want to get something very important out first. Is it Stoughton or Staunton? Because think I've screwed that up several times.
I've always pronounced it Stoughton,
Stoughton,
but I'll
well.
take anything at this point.
I'm either Borgula or Borgula, and I answer to both. Because I think when my grandparents came over here, it was changed completely anyway.
Yeah,
All right, so
I feel your pain there.
I want to talk about officer-created jeopardy.
Sure.
And I'm going to start because I want to get a definition that you state in your report that's specific to this case.
Sure.
Is that fair? So officer-created jeopardy is, in essence, a manner of describing unjustified risk-taking that can increase the likelihood of injury to officers and can, correspondingly, increase the likelihood that officers will use force to protect themselves from a threat of physical harm that they were in part responsible for creating.
Yes.
So you agree with that? And I think you kind of compared it to like a standard of care.
Generally accepted practices I would describe as sort of a professional standard of care or common norms of professionalism. Officer-created jeopardy is one of the concepts that is generally accepted, but sort of generally accepted principles and practices broadly are what I would describe as more like a standard of care.
Okay. And so I want to, officer-created jeopardy, you say is generally accepted. And that's a term that gets thrown out a lot, especially by experts as yourself in the use of force category, right?
Yeah, either the term or the concept underlying it, yes.
And it's kind of the lens through which you're going to view whether or not an officer acted reasonably or unreasonably. Is that fair?
When assessing the tactical decisions, yes.
Yes, because you have to compare it to something. You can't just look at it and say, well, I think that's unreasonable for any good reason. It has to be, I think that's unreasonable because he didn't follow generally accepted police practices or tactics.
Correct.
Fair? Okay. All right. And so you define generally accepted principles as refer to those concepts and theories that are widely known, acknowledged, and relied upon in the field. Is that fair?
Yes.
And generally accepted practices refer to protocols, techniques, and procedures that are widely known, acknowledged, and relied upon in the field.
Yes.
Okay.
I'm getting all this out of your report, so I just want to get to where we're going with officer-created jeopardy.
Sure.
And so they become generally accepted when well-educated, well-trained, and experienced professionals would agree that it is conventional, customary, and reasonably standard. Correct?
Yes.
And you indicate that there are various organizations that believe officer-created jeopardy, the consideration of whether or not an officer put himself at risk is generally accepted.
Every police organization that I'm aware of pays attention to an officer's tactics. So yeah, an
Sure.
officer who uses poor tactics may be subject to at least counseling or retraining, if not discipline, on the grounds of officer safety. Yes.
Okay. And so there are certainly sort of post-action reviews of whether or not an officer acted reasonably.
Yes.
Yes. It happens all the time. Training.
Sure.
That's how we get good police officers, right?
And how you continue to improve practices of your current officers. Yes.
Okay. And so you say that officer-created jeopardy is generally accepted because and I think you mentioned some DOJ consent decrees.
That can be one area where generally accepted practices are reflected. Yes.
And you talk about a civil settlement, U.S. versus City of Albuquerque.
In the description of vehicles, I think, yes.
Okay. It's one of the things that you relied upon in your report and that the prosecutor put in her motion. So you're familiar with that particular settlement agreement?
I would have to go back and look at it offhand, or excuse me, I would have to go back and look at it. I don't remember the details offhand, but yes.
Okay.
At least in broad terms.
So in the civil context, DOJ in that consent decree discussed officer-created jeopardy. Is that fair?
Again, I don't remember if they use that particular term, but certainly police tactics, yes.
Okay, well, there's a difference between police tactics because everything is police tactics, right?
No, not everything.
Well, everything related to what the police officers are doing when they're making an arrest, for example.
No, tactics have a very particular definition here, right? We're talking about how officers navigate or mitigate potentially risky situations. So there's a lot within police tactics, but not everything that police do is tactics.
And when you're talking about generally accepted, I just want to understand here. You're saying, with regard to officer-created jeopardy, certain tactics put them in an unjustified risk, right?
Use of poor tactics can, yes, absolutely.
And certainly, all experts would agree that there are situations where certain tactics would create a risk, right?
Yes.
Okay. And that's what you're saying.
Yes.
And you're talking about, when you're talking about how it's generally accepted, you're just talking about organizations that are discussing best practices when using police tactics.
No, it could be an agency that's implemented that generally accepted practice through policy or training. It might be an organization like IACP that's not presenting it as a best practice, but is instead just reflecting, for example, this is part of a national consensus, right? That's certainly what I would describe as generally accepted.
So you talked about the International Association of Chiefs of Police, and they have a discussion paper.
Yes.
Okay. Police Executive Research Forum.
Yes.
Moving Beyond Speculation and Towards Empiricism. That's a 2007 publication.
Yes.
In-agency policies, and you referred to a 2008 evaluation of the New York City Police Department firearm training.
Yes.
And firearm discharge review process.
Yeah, that was by the Rand Corporation, if I recall.
So New York has discussed officer-created jeopardy with regard to their practices, right? I assume it's related to the New York City Police Department?
Yes, it was. That particular one is relevant to officers drawing a weapon.
Okay, and the Department of Justice does not train its agents on officer-created jeopardy theory itself. They don't use that term, correct?
I don't know if they use the term. They certainly train on tactics and
Sure.
using good tactics and avoiding bad tactics. But I don't know if they use that term specifically.
And it's your opinion that there are certain circumstances where tactics caused the officer, in this case, to be in a situation where he had to use deadly force, right?
Sorry, can I ask for the context in which you are asking me that? In my role as an expert, I don't get into causal claims, right? In my research as a scholar, yes, absolutely. But as an expert, when you get into things like but-for or proximate causation and what is responsible, right? Who is responsible? That is beyond my scope. What I'm analyzing is an officer's tactics at the time. And regardless of what happens after, an officer can use a poor tactic that is officer-created jeopardy, that creates an unavoidable and unjustified risk, kind of regardless of what happens after that.
Well, I'll give you some context, because you wrote a report. You and Nicholas Bloomfield wrote a joint report.
Yes.
For this case.
Yes.
And you have 7 opinions with subparts, right?
Yes.
Okay. Can you tell us which opinions you're going to be providing as part of your testimony?
I guess that depends on which opinions I'm asked about. I would assume potentially all of them, but I don't know which opinions I'm going to be asked about specifically.
It's my understanding that you're going to separate the joint report into different opinions. Is that not your understanding?
I try not to get into issues of advocacy. I'm happy to talk about whatever is within the scope of my opinion and report, but I don't know specifically. I can tell you sort of in a broad sense, I don't know if that gets into issues of discussions that I've had with the prosecutor or not.
Okay, well, and I don't want you to get into those. I thought you might have an understanding of what you're going to testify about, in particular to your report. Can you tell us how officer-created jeopardy influenced your opinions or became the opinion in your report? Which opinions are related to officer-created jeopardy?
Sure. There's the opinion about the brief foot pursuit after the initial sort of hands-on and pulling away, where officer-created jeopardy is a component of that opinion. There's an opinion relating to the deployment, of the taser, where officer-created jeopardy plays a relevant role.
Those happen to be 3 and 5. Does that sound right?
Yes.
Okay. And then there's a 7th opinion regards to whether a reasonable officer could be in fear of the taser. Does officer-created jeopardy influence your opinion in that circumstance?
I'm not entirely sure what you're asking.
Well, I'm trying to figure out whether there's any relevance to your other 2 opinions. If it doesn't affect your opinion and the ultimate opinion that he wasn't in fear, or a reasonable officer wouldn't be in fear.
Okay. Yeah, sure. So my opinions on officer-created jeopardy are a way of describing or identifying when there is a problem with an officer's tactical decision. That is, an officer's tactical decision is problematic or inconsistent with generally accepted practices, sometimes because it constitutes officer-created jeopardy, right? That is part of the standard, part of why I am coming to the conclusion about an officer's tactics. When it comes to an officer's use of force, I will often note, as I believe I did in this case, this use of force came after some tactical decision that an officer made. But it's the use of force, in my view, like I am not analyzing the use of force as more or less reasonable because it was the result or not the result of officer-created jeopardy, if that makes sense, right? I'm looking at a use of force and saying, is it a proportional response to the imminent threat that existed at the time? And we can sort of segregate out why did that threat exist at the time? Was it a result of officer-created jeopardy or not? That might be legally relevant. But that's in a case where I'm retained as an expert, that particular question is above my pay grade, right? It is not my job to figure out what is legally relevant. I'm just analyzing an officer's actions at different points and comparing them to this generally accepted principles and practices.
Okay, and you were asked whether or not the foot pursuit was reasonable, and you gave an opinion
Yes,
in the report,
yes,
and you anticipate you could testify about that. And you also were asked to give an opinion about whether or not using a taser in close range was reasonable, and you gave an opinion,
yes.
okay? Do those opinions have any relevance to the ultimate question for this court, whether or not Officer Schurr was reasonably in fear?
I'm not trying to be squirrely on this. Again, I think that's a legal question. The question of relevance is a legal question and not one that I'm in a good position to answer, right?
Okay.
Whether it's legally relevant, I don't know enough about Michigan law to say. I'm not here to apply Michigan law. Could it be? Sure, there are definitely jurisdictions that apply an officer's actions prior as relevant using sort of standard but-for and proximate cause concepts, but that's not my role as an expert to do.
Okay, so you don't know whether or not it has any relevance?
Yes.
Okay. And you say you're not following Michigan law when you form those opinions?
I'm not an expert in Michigan law. I'm not holding myself out as an expert or applying Michigan law to the point of saying this is criminal, this is not criminal. That would not be appropriate, or even, right, this is consistent with Graham v. Connor, or this is a Fourth Amendment violation. This isn't a Fourth Amendment violation. That would be inappropriate for an expert.
Okay. And so you talked a lot about scholarly articles, making it generally accepted. You talked about two amici briefs. I never know, is it amicus plural or is it amici plural?
I think amici is the plural.
It just sounds right, but I don't know if it is. So you
I'm-
filed two.
Two of them just in the Supreme Court that touch on issues of tactics. One of them in the Fifth Circuit that touched on tactics to some extent, yes.
The Fifth Circuit case was Barnes v. Felix?
The Fifth Circuit case, but I filed that, so that's a Supreme Court case. The amicus was in the Supreme Court case.
Did you file an amicus in the Court of Appeals as well?
No, the Fifth Circuit case there I think was TIMPA, T-I-M-P-A.
Okay, and that was a civil case, Barnes v. Felix?
Yes.
And there, I mean, the issue was the moment of the threat doctrine. Would you agree?
Yes.
Okay, and what you're looking at as to whether or not the totality of circumstances includes, in this case, the officer jumped in front of a car.
Yeah,
that-
jumped onto a car, yes.
Jumped onto a car. The person that had been pulled over, or at least called the police, I believe started moving forward just a little bit, and the officers like jumped on the car.
Correct.
And then the guy took off, and the officer was like, I gotta shoot him now, because I'm gonna die, right?
Yes, more or less.
It goes all the way up to the Supreme Court, and you would agree that a lot of people were interested in that case, right?
Oh, sure.
And the reason it goes to the Supreme Court is because it's an unsettled issue of law.
Yes, there is a circuit split on particularly this moment of threat doctrine, yes.
Right. And so, and the Supreme Court, as they often do, they hear all this argument, they give amicus briefs, they got DOJ, everybody seems to be involved. And did you listen to the oral arguments?
I did, yes.
Okay, and the Supreme Court's like, we're just going to define this very narrow issue because they don't really want to decide officer-created jeopardy right now. Is that fair?
Until the opinion comes out, I don't know what they're going to do. There
Would
was
you agree
certainly
with my assessment?
So Justice Kavanaugh seemed to be looking pretty broadly and wanted to talk about whether the officer's actions were reasonable. There were other justices who just wanted to, or at least were asking questions that I would take indicate they are more interested in, could we just say moment of threat doctrine is not a thing without getting into any broader questions. As always, the court is not an it, it's a they, so different perspectives, and I have no idea where that case is going to go.
Neither do I. I can't predict the Supreme Court. I just listened to
Yeah.
the oral argument as well. And, you know, to the extent officer-created jeopardy came up, you had both sides saying, well, this isn't about officer-created jeopardy, at least because they wanted the case to go forward if you're the plaintiff, and it's a civil case.
Yes.
And the defense, they were like, we don't want this to become the standard justices because that is not where we think the law is. And so both sides are arguing that. So would you agree with me that at least the Supreme Court has not decided whether officer-created jeopardy is settled law?
As a matter of Fourth Amendment law, the Supreme Court has not clarified whether, for purposes of establishing the reasonableness of an officer's use of force under the Fourth Amendment, whether you include an officer's pre-seizure actions, that is, actions before the use of force, or not.
Okay.
Yes, I think that's fair. There's a roughly 8-4 split on that. This Barnes v. Felix may give us an answer. We'll find out.
I don't think so, but we'll see, right? So, and I did read your brief. There's a lot in there about officer-created jeopardy and, considering the actions of the officer in a Fourth Amendment context. All right, but we don't know whether or not how that's going to come out just yet. Now, you've mentioned some scholarly articles. I noted one by Professor Cynthia Lee.
She wrote an article just 2 years ago or so on the issue. Yes.
That was the most recent one. I think it was 2021.
Time flies. Yes.
Yeah. So, but in there, she's asking for courts and to be generally accepted this reform effort, as she put it, because it was not an articulation of the current constitutional or law enforcement standards. She's urging the U.S. Supreme Court to, quote, go above the constitutional floor and consider the officer's pre-seizure conduct to assess the reasonableness of deadly force.
Yeah, I read her article to be arguing, particularly in cases of criminal liability, but liability more broadly, that applying these concepts of but-for and proximate causation, an officer's culpable conduct prior to use of force should be part of the evaluation for use of force.
Okay.
Yes, that's what I read her argument to be.
And you brought up criminal cases. There has been applications in other contexts where you sort of balance the negligence or recklessness of the officer versus what the suspect was doing to sort of determine whether or not, in the totality of circumstances, the officer's actions were reasonable, right? Like qualified immunity cases?
With Fourth Amendment qualified immunity, we're looking at an officer's actions as objective reasonableness, so we don't actually look at individual culpability in the sense of like mens rea, right, with specific mindset. We're just looking to determine whether their actions are objectively reasonable. In some states, under their civil or criminal standard, they might apply that particularly with reckless behavior that results in a homicide or use of force or something like that. Sure.
And then, so an officer's reckless behavior could be considered in 1983 actions. That's another context.
So that it maybe it can be, at least sometimes. It depends on whether let's say that there isn't a use of force and we just have reckless behavior. It depends on whether that reckless behavior is an independent Fourth Amendment violation or a violation of the ADA or something like that the 1983 provides a cause of action to. It may not, right? It may not establish an officer's reckless behavior without, say, harm to a civil plaintiff might not amount to a Fourth Amendment violation where there is a plausible 1983 claim.
Okay. And even in those contexts, there's a lot of learned discussion on whether or not that should actually apply in civil context. Is that fair?
Sorry, whether
you should consider the unjustified risk of the officer.
Sure. Exactly how that fits in or should fit into the legal framework is something that, scholars and policymakers discuss.
Have you seen it in criminal cases where you're testifying about something that preceded the moment of the threat, that doesn't seem to have any direct bearing on it, but we're asking the jury to consider the negligence or recklessness of the officer and deciding whether or not he was honestly and reasonably in fear of great bodily harm?
Sure. So not I like take cases that I've had some role in away for a second, like California's standard, for example, for recklessness or negligence includes not just the moment at which force is used, but the actions by whomever, including an officer, right, that foreseeably create those conditions. And if someone's actions, I forget what case that is in California, but if someone's actions foreseeably create the conditions in which they shoot someone, right, then we say, okay, well, were those actions reasonable? Because if someone acted recklessly at point A and that led directly to them taking a life at point B, then again, this is just a fairly straightforward application of but-for and proximate causation.
Right, and they're in a California case, I don't know the name of it, what you're talking about either, but you're talking about whether the actions at the time deadly force was used were negligent, because it could be negligent homicide or something like that, right?
Sure, yeah.
Okay. How many cases, any cases in Michigan that you're aware of?
No.
All right.
None. I'm neither aware nor not aware of any. Again, I did not research Michigan case law for this at all.
Any second-degree murder cases of which you're aware?
In Michigan?
Anywhere in the world?
Yeah, Colorado just convicted an officer on what would be the idea was tactical errors early in the. This is the conviction of Buen, B-U-E-N. That is a case that I worked on, and the verdict certainly suggested that the theory was tactical errors that led to the use of force created that and were culpable.
So they had a verdict form that said that?
No, it's the I forget what it's called in Colorado law, but it was it was not like the intentional. It wasn't the murder statute or the voluntary manslaughter statute. It was whatever Colorado has as their other version of that.
Negligent homicide?
I think it might have
I
been
think it was.
whatever that something like that.
In a self-defense case to murder, have you seen that anywhere?
Sorry?
Well, this is a murder case, and Officer Schurr is charged with second-degree murder.
Right. I'm sorry.
Intentional killing.
I just didn't understand the question.
Okay, and the defense is self-defense.
Okay, I see.
Okay, that he was justified in using self-defense because he honestly and reasonably believed he was in fear.
Okay.
Okay. Have you seen an examination of the conduct that you might have believed or some other expert might have believed was unjustified and put himself in risk, therefore he could no longer argue self-defense?
Yes. So that's like the aggressor component of self-defense. And again, I'm not speaking of any one case specifically. And sorry.
In a murder context.
Yes. Yeah. So I don't testify. I don't take cases as an expert in like civilian self-defense where we see more of these self-defense cases. But in criminal law, I have taught self-defense, and one of the aspects of self-defense is unlawful conduct prior to the moment where self-defense is used can render someone an aggressor. That's not in the policing context, right? But it's certainly conduct prior to the use of deadly force that then affects the culpability of that use of deadly force.
Well, and not if you're not in the policing context, we don't have private citizens effectuating an arrest, for example, right? You can't pull someone over if you're a private citizen.
I certainly hope that's the case.
Well,
they do sometimes, but yeah, it's not great.
And you're not familiar with Michigan law.
No.
Okay. Are you aware whether or not there's even a statute about when a police officer can use deadly force in the state of Michigan?
I'd have to go back to the appendix of my book because we pulled all of the state statutes and cases. I think there's a statute, but I have no idea what it is offhand.
Okay. All right. So I want to talk about sort of the consequences of and relevance of these opinions that an officer might have been put himself taken unjustified risks to put himself in a situation. So let's say in this case you have an opinion that Officer Schurr should not engage in a foot pursuit.
Okay.
Okay. And time goes by, about another minute or two, he's in the position where he has to decide whether or not to use deadly force.
Sure.
If you find, if it's your opinion that he was unjustified in doing the foot pursuit, does that foreclose him from maintaining the defense of justification?
Are you asking how my opinions as an expert would relate those two, or are you asking like as a legal matter? Because the answer to the latter is I
You don't know.
I don't know. That depends on whatever the law of the jurisdiction happens to be. I'm no idea.
Okay.
Um,
And I think you said before, well, we could talk about causation because I promised you we'd bring it up, but, I mean, courts have generally considered whether the officer's actions leading up to the use of force were reckless and whether those actions were immediately connected to the need to use deadly force. That's something that you said.
yes.
Okay. So they considered whether there's basically proximate cause, right?
Yes.
Okay. So if you're finding that he shouldn't have engaged in a foot pursuit has no proximate cause, is there a cause between the foot pursuit and the fact that he had to use deadly force later on?
Again, sorry, can I clarify? If you're asking about sort of the scope of my opinions, I don't get into proximate cause at all, right? I'm just analyzing separate points, separate decisions, separate actions separately. If you're asking legally, again, with the giant caveat that I am not an expert in Michigan law and would not want to testify about law, even when I did know what the law is, again, I think you're applying sort of normal principles of superseding intervening cause there. That is, you have an event that is culpable in some way that is a but-for cause of the ultimate result. Is it the proximate cause? I don't think there's anything sort of special about applying superseding intervening causes.
Okay, so
That's like academic law professor answer, I apologize. But in terms of as an expert, I'm analyzing what happened, what the officer did at point A, what the officer did at point B, and I'm not saying anything about point B. Sorry, let me rephrase that. I'm not saying anything about point A when I'm talking about point B.
okay, so you're segregating these opinions.
I am.
You're looking at kind of like sort of with blinders on, okay, I'm going to look at the foot pursuit. Was that done properly?
Yes.
All right, and you actually broke it down into 7 opinions, 4 of which, or 3 of which, you thought the officer did act reasonably.
Yes.
The stop,
Yes.
the initial grabbing and pulling to arrest.
Yes.
Right? And then things went south, in your opinion, when he chased him.
Yes.
Right. And I'm summarizing here.
Yes.
Because we're not going to get into the opinions now.
Okay.
The question is, for the court, and what the court's trying to decide is whether or not your opinions matter to the jury.
Sure.
Okay. But you're segregating these particular findings of unreasonable behavior.
Yes. So I mentioned in, sorry, I forget which opinion number it is. I think it's 4 offhand, about the sort of use of the empty hand strikes and knees, right? I mentioned that opinion. That occurred because of the foot pursuit, but that's not what my opinion rests on, right? Like you could take the foot pursuit out of the picture entirely and still have that opinion.
The ultimate opinion.
Onto those use of force, yes.
Okay. Okay. And the ultimate opinion, or the final opinion, is that no objectively reasonable officer, presuming they knew that the second cartridge of the taser had been discharged, would have been in fear of incapacitation and therefore could not have been in fear of losing their weapon and therefore could not be in fear of great bodily harm or death.
I might say it a little bit differently, but yes.
Probably better than I just said. Right?
I don't know about that, but yes.
Okay. And you view those separately in and of themselves. Okay, so I want to talk about the standard or the burden for officer created jeopardy, because it seems to me that the opinions, opinion 3, opinion 5, suggest a negligence standard. He should have known not to chase. He should have known not to use the taser at close range. Therefore, his actions were unreasonable. Is that fair?
No, I am not imbuing any mens rea at all. I'm just looking at what he did and comparing that to generally accepted police practices, and it was either consistent or inconsistent. The degree of culpability for that is not something, like, culpability is ultimately a legal determination, not I think an expert determination. So I can say this did not match, or this did match generally accepted principles. This was or was not in alignment with generally accepted principles. This is or is not what a reasonable officer applying generally accepted principles or practices would do. But I'm not saying therefore there was negligence, recklessness, knowledge, intention.
Now, you're saying unreasonable. Maybe, I'm not a civil practitioner. I used to be many years ago. But that says to be a sort of standard of care that he violated. A reasonable officer wouldn't have pursued him.
Your
Sure.
Honor, I'd like to launch an objection at this point. I think we veered away from the reliability and foundation of his opinions, and we're getting into a second bite of the apple at cross-examination at this point.
I think so, Mr. Thornton. I'm not sure if you have any other.
The officer created jeopardy theory is based on a standard.
California cases.
That's all, everything I'm talking about is the officer created jeopardy theory, Your Honor.
Okay, I think some of that stuff kind of exceeded the scope of that, like asking him further along. But if you can, I don't know how many more questions you have with respect to the officer created jeopardy issue.
I'll try to wrap it up, Your Honor.
Because I'm only trying to figure out if his opinions would be reliable.
Okay,
Reliably applied.
you're not going to consider whether it's relevant to the jury's
I
consideration?
think I've already determined that previously. Matter of fact, you mentioned that before we had him come on, that I've already determined that his testimony was relevant.
So you've already decided that the officer created jeopardy theory is relevant?
I'm trying to find out if it's reliable or not.
Okay. Well, I'll ask more questions on that, Your Honor. Well, and to go back to whether or not it's generally accepted, you've heard of Force Science, the agency?
Yes.
Okay, and you're aware that, Von Klein, have you heard that name before?
Yes.
Okay, and you're aware that he does not believe that the officer created jeopardy theory should be something to consider in the, when considering that whether the use of deadly force was reasonable?
So whether officer created jeopardy is legally relevant to the determination of whether a use of force is reasonable, yes, I understand he has an opinion about that. He's also talked about, including on podcasts, the importance of police tactics and how they can affect ultimate outcomes. I think he and I agree on that point.
All right. You would agree with me that there are people that disagree with your opinion that officer created jeopardy is not reliable, or is reliable?
I'm not sure I understand.
Well, you've turned to a lot of scholarly articles. Can you, and obviously Mr. Bloomfield probably agrees with the theory. I don't even know.
I would hope, I can't speak for him, but I would hope he agrees with what's in the report.
Well, right? You guys wrote it together?
Yes.
Okay. Did you consider, when determining your opinions, did you consider GRPD trainings?
In assessing what may be reflected in GRPD or in how GRPD trainings may reflect the generally accepted practices, yes. It's not my role as an expert here to identify whether the officer acted consistently or inconsistently with the agency's standard, right? I assume the agency is an expert in its own standard. So I'm not going to talk about whether the officer violated agency policy or did not violate agency policy. But it was in the scope of things that I reviewed.
Right. You're just deciding whether or not, in your universe of generally accepted police practices, whether or not his actions were unreasonable in specific contexts.
Right. Whether they were consistent or inconsistent with those generally accepted practices. Yes.
Okay. And so you have no idea whether or not Officer Schurr is aware of any of these officer created jeopardy or any of these other generally accepted police practices that you are going to talk about today?
No, I can't talk about his knowledge or lack of knowledge about any of them.
Okay.
Is this the California?
Thank you, Your Honor.
Ms. Blanchard, any other questions?
No other questions from the people, Your Honor. I do have a brief legal summation if the court's interested, but no other questions.
Yes, go ahead.
I know that people have filed a brief legal memo with the court summarizing the law that we're operating under. And I would just want to emphasize that when considering reliability, the court is just making sure that the expert's opinion is resting on a solid foundation. It doesn't need to be a universally accepted opinion. All experts don't have to agree, or his opinion need not be proven 100% correct. Just that it's based on sufficient facts, data, a reliable methodology, and comes from sufficient personal knowledge, training, or experience. And I would represent to the court that Professor Stoughton's testimony today shows his wide source material, his expert publications, his citation by case law, courts, other experts, and being hired to provide expert consulting, filing amicus briefs, and then not only that professional experience, but also his personal experience as a trained law enforcement officer who has received training on the topic of officer-created jeopardy, all go toward establishing a solid foundation for his expert opinions that would then allow the people to argue how that fits under Michigan law and supports the facts of this case. Thank you. And he's also how he is.
Thank you.
I was just.
Thank you.
And I'm looking for who I will not be saying.
Thank you, Your Honor. The prosecutor, Your Honor, is asking you to create use of force law unknown to Officer Schurr. There's not a single Michigan court that has accepted this theory in a murder case. Your Honor, the U.S. Supreme Court in Barnes v. Felix declined to consider that it's not a theory. It's still yet to be litigated. Professor Stoughton acknowledged that it's an unsettled area of law. This court should not be the first in Michigan to accept Professor Stoughton's theory. There are citations to law review articles and civil cases. This is not the context in which this applies. It's not reliable because it has no application, especially in the case of alleged self-defense. It doesn't account for intervening cause. It doesn't account for the standard negligence versus recklessness. And the opinions here are based on negligence. He acted unreasonable with a foot pursuit. He acted unreasonable because he stood too close to him with a taser. Therefore, he can't argue self-defense. That's the suggestion by putting that information in front of the jury, that he's created this unjustified risk that he is foreclosed from defending himself, no matter what happens. That's the problem, and you're going to confuse the jury completely by letting Professor Stoughton give opinions about things that based on this theory. Your Honor, it's absolutely dangerous. If we're going to ask Officer Schurr that once you do a foot pursuit and you're negligent, that you can no longer defend yourself or others. That is what this theory says. That is what we're going to be asking the jury to consider, whether or not this has any relevance whatsoever. This is a murder case. The issue is whether or not he intended to kill somebody, and the issue is also whether he was justified in doing so. We ask this court not to accept this theory. It has no bearing whatsoever on this matter. There are other areas, as in the expert's report, that they can opine upon that actually might matter. But the theories of the foot pursuit and standing too close are not reliable in the context of this case. Thank you, Your Honor.
Well, as I previously stated, I wanted to hear from the witness regarding his opinion because under 702, MRA 702, a witness qualified, who's qualified as an expert by knowledge, skill, experience, training, etc., may testify in the form of an opinion if the proponent, which would be the people, demonstrates to the court that it's more likely than not that his opinion would help the trier of fact to understand the evidence or determine the fact of the issue, that testimony is based on sufficient facts or data, and it is a product of reliable principles and methods, and that the opinion reflects a reliable application of the principles and methods to the facts of the case. Here, there's no dispute that the witness, Mr. Stoughton, is qualified to be an expert as he has the requisite knowledge, skill, experience, and education. Again, the issue is whether or not his testimony would be the product of reliable principles and whether his opinion reflects a reliable application of the principles to the facts of this case. As he testified to, well, first I'll say here, part of what the jury has to determine, they have to take into account all of the circumstances in the case, not simply the moment of the shooting, but all of the circumstances. And there's been a lot of evidence and testimony surrounding what the circumstances were at the time that this incident occurred. In considering that, after hearing from Mr. Stoughton, he clearly testified that officer created jeopardy, that particular theory, is a term of art, and that term of art, which was coined in the 90s, not by him, but by someone else, that particular term of art, officer created jeopardy, is regarding tactical decisions made by an officer which is subsumed within generally accepted police practices. So because I believe that he has testified sufficiently that he has applied the facts in this case to the generally accepted principles and practices which apparently are nationally recognized and nationally accepted, I believe that because officer created jeopardy in and of itself is not a particular method, rather a theory, again, subsumed within those accepted police practices. For those reasons, I am going to allow him to testify as an expert in use of force and generally accepted police principles and practices, because I believe that he's testified that he does, again, possess the requisite knowledge and training and education, and that his testimony would be relevant and could help the jurors understand the evidence in the case. So with that, what I'm going to do is we're going to break for lunch and come back at 1 o'clock. I've already let or put word to the jurors that they can have lunch and we'll continue at 1 o'clock. Is there anything else before we break?
Nothing, Your Honor.
There's some whispering to my right, Your Honor, one moment. No, Your Honor.